convened pursuant to the arbitration agreement in the supply contract between LifomaxWoodbuild Sdn Bhd and Mammoth Construction Sdn Bhd. It shall be governed by the AIAC Arbitration Rules 2023. The case concerns the supply of construction materials and related claims for payment and damages. The sole arbitrator's role is to ensure that these proceedings are conducted fairly, efficiently, and in accordance with the applicable rules and procedures. I confirm that I am independent and impartial, and I have no conflict of interest in this matter. We shall proceed with procedural fairness and equal opportunity to be heard. This hearing is being held pursuant to the terms of reference and the procedural timetable agreed upon by the parties and the tribunal. We will now proceed with the hearing as scheduled, starting with the claimant of any submission, unless either party wishes to raise any preliminary issue. Okay. Parties, please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Before we begin, I kindly remind the parties that the proceedings are confidential and that all participants are expected to conduct themselves with courtesy and professionalism throughout. Counsel for the claimant, please begin with opening submission.
Thank you, Mr. Arbitrator. This case concerns the delivery of construction grade steel bars from the claimant to the respondent under the multiple contracts. The goods were delivered with appropriate documentation, including meal certificates. The respondent failed to make payment totaling RM1,447,087.05. The allegations of defects is post-delivery and unfounded. The claimant seeks recovery of the principal amount and RM2.8 million in damages due to reputational loss, storage, retrieval, and legal costs. That's all from the claimant.
Thank you, Counsel. Counsel for responding, you may begin your opening submission.
Thank you, Mr. Arbitrator. The respondent strongly contests the plea. The steel bars were found to be defective and did not comply with grade 500 standards. Verification with arm steel showed forged meal certificates. Multiple third-party laboratories confirmed the non-compliance. The claimant also issued an apology letter and later resolved the steel bar without notice or transparency. This is a clear breach. And late, the respondent counterclaims 650,000 ringgit for replacement materials, project delay, and testing costs. That's all for the opening statement for the respondent part.
Thank you, Counsel. Counsel claimant, you may begin your argument and issues.
Thank you, Mr. Arbitrator. Before calling our witness, I will outline the claimant's argument in relation to the key legal and factual issues in this case. The first issue, whether the claimant fulfilled its obligation under the contract. The claimant delivered the goods as agreed. Each delivery was supported by documentation. Delivery orders were acknowledged and signed by the respondent. Meal certificates were provided and believed to be genuine. No written rejection or protest was issued by the respondent within the contractual window. Second issue, whether the respondent validly rejected the goods or notified the claimant of any breach. In this issue, the respondent failed to reject the goods within the 14-day inspection period. There was no formal notice, no joint testing, and no immediate rejection after the delivery. The law is clear. Under the Sale of Goods Act 1957, failure to reject in a reasonable time is deemed as an acceptance. The first complaint may come only after the claimant began demanding payment. And the third issue is that whether the claimant is entitled to payment and damages. The claimant delivered, the respondent accepted, but payment was withheld without cost. The apology letter sent by our client was informal and issued in good faith to preserve the business relationship. It does not amount to an admission of liability. Following police closure of the matter as NFA, the claimant retrieved and sold the bars to mitigate its losses. The resale proceeds were absorbed in offsetting storage, transportation, and resale costs. The claimant respectfully asked the tribunal to award a full claim amount and RM 2.8 million in additional damages. That's all from the claimant. Thank you.
Thank you, Counsel. Counsel for respondent, please present your argument.
Mr. Arbitrator, we now present the respondent legal arguments and the core issues in dispute. The first issue, whether the claimant breached the contract by supplying defective goods. The evidence is overwhelming. 4 separate and independent labs confirmed that the steel bars failed to meet grade 500 standards. These results were based on credible, industry-recognized procedures. Most significantly, Armsteds themselves confirmed the means certificates were falsified. This is not a minor defect, it goes to the heart of the contract. The second issue is whether the respondent acted reasonably in withholding payment. Upon receiving the expert confirmation of the defect, we lodged a police report. The bars were taken into police custody and then later returned. The apology letter issued by the claimant admits the bars were unrespected. The claimant's subsequent decision to resell the goods without informing us further indicates bad faith. We had every right to reject payment under Section 40 and 75 under the Contract Act 1950. And the third issue, whether the respondent is entitled to damages. The defective goods caused us to halt the project. We had to reorder and retest all new supplies. We also suffered reputational harm with our consultants and incurred costs for independent testing. We submitted the counterclaim of 650,000 ringgit is supported by clear documentary evidence and should be allowed to view. That's all from the respondent.
Thank you, Counsel. I will now invite claimant's counsel for examination of the claimant position for confirmation.
Thank you. We now call. Thank you. We now call the claimant to clarify its position. Mrs. Maisara, did your company deliver goods in accordance with the purchase agreement?
Yes, of course. All goods were successfully delivered on time, and as well as the documentations.
So, were you informed of any issue with the goods at the time of the delivery?
No, there were no complaints from the respondent until we requested for the payment.
I see. So, what was your intention in sending the letter of apology?
It is not an admission fault, but a goodwill gesture to maintain business relations.
I see. So, what did you do after the police report was resolved?
Of course, we collected goods and sold them back to reduce our losses.
Can I have some questions?
Yes.
Why did you notify the respondent before selling the goods?
We believe the goods were landed, and of course, we need to mitigate our loss.
So, do you acknowledge that the steel was found to be below standard in multiple test reports?
I am aware of the reports, but I'm questioning the accuracy and sampling process. That's all.
That's all my questions. We now call the respondent to clarify his position. What prompted your company to withhold payment?
Our engineer had discovered some inconsistencies in the steel bar and this raised serious concern to us.
So, did you verify the pin certificates?
Yes, we do verify it with M Steel and they were confirmed to be forgeries.
Then, what action did you take after confirming the defect?
As soon as we noticed the defect, we lodged a police report, withheld the payment and initiated independent testing.
Mrs. Izzati, can I ask some questions?
Yes, please.
Did you issue a formal rejection of the goods within the required period?
No formal letter was issued, but our investigation began immediately and we acted immediately.
So, did you offer to return the goods?
No, the goods were handed to the police and were not in our control.
Thank you. I think that's all for my question. So now, Mr. Arbitrator, can I call our first witness? first witness?
Yes, Counsel, you may.
Thank you. I shall now call Mr. Lim Dalfong, which is Operations Manager at LifomaxWoodbuild Sdn Bhd.
Mr. Lim, please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I
Alright, thank you.
So, Mr. Lim, did your company deliver the goods in accordance with the contract?
yes, we delivered them in full on time with supporting document. The respondent also signed the delivery orders without reservation.
I see. So, were you notified with any of the defects?
No, nothing formal. We only learned of the issue of the chasing for payment.
So, why was the letter of apology was sent?
It was sent to preserve a commercial relationship. It wasn't meant as an admission of fault.
I see. So, what happened to the bonds?
I think we retrieved them after the police classified the case as NFA. We later sold them to reduce our losses.
Mr. Lim, can I ask some questions?
Yes, sure.
Do you deny the test report showing substandard steel?
We were not involved in the sampling, so I cannot verify the accuracy of this test.
Did you notify our client before sending the box?
No formal notice, but we assume it was within our rights given the circumstances.
Is there any more question from the Counsel? Thank you, Mr. Lim. You may step down.
Mr. Arbitrator, may I call our second witness? Mr. Arbitrator, may I call our second witness?
Yes, Counsel.
We now call Mr. Tom Tan Cheng Wong, Project Engineer for Mammoth Empire Construction.
Mr. Tom, please raise your right hand. Do you solemnly affirm that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Tom.
So, Mr. Tom,
Yeah.
what triggered concerns about the steel?
Actually, our site engineers noted that there is a irregular surface textures, and then we do check with the mesh certificates, or which is steel, and then there was a forgery. And we also did independent tests, and we confirmed that the steel was below grade 500.
So, how did this impact your project?
It has actually really have a serious impact, which is we have a serious delays, and then we need to reorder all those materials again, and we spend heavily on structural assessment and consultation.
Mr. Tan, can I ask some questions?
Yes, please.
So, did you raise a formal rejection within 14 days?
Actually, we don't have any kind of formal notice, but we actually act once we had an expert evidence.
I see. So, why did you not return the bars?
Actually, they all was surrendered to the police, and then we didn't touch them after the report.
Thank you. I think that's all.
If there is no more question, Mr. Tom, you may step down. I will now ask question to the both parties. Counsel for claimant, you will begin to answer, then followed by the counsel for respondent. Counsel, why did both parties not arrange for joint sampling and testing?
From our part, the respondent never proposed joint testing. We were unaware of the allegations until after the payment was due.
So, we acted based on agency, the forged documents, and agency of project timelines required immediate testing.
My second question is, was any mediation attempted before arbitration?
On behalf of our part, no. We attempted to engage through letters but received no formal reply.
In our part also, no formal mediation was attempted. Once legal liability became apparent, we escalated.
Council, and my last question will be, could either party provide full documentation on material source and quality assurance?
On behalf of the claimant, we do have the documentation from our supplier, but the mill certificates were believed to be genuine.
So we obtained verification from Arm Steel directly, confirming there is forgery.
Alright, thank you, Council. I will now give the full award and the judgment. Having read full submission, the tribunal now delivers its finding. Arbitration is grounded in principle of procedural fairness, due process, and party equality. Both parties were given equal opportunity to present and rebut evidence. First, the claimant delivered steel bars with documentation that was later confirmed to be forged by the manufacturer. This undermines the reliability of the claimant's performance. Second, the apology letter issued by the claimant, although non-binding, functioned as corroborative evidence of knowledge regarding product defects. The third one is, the respondent acted within commercial reasonableness by testing the materials and withholding payments. And lastly, the claimant failed to disclose proceeds from the resale of the bus, coupled with failure to account to the respondent, violates the equitable standards. On the balance of probabilities, the tribunal finds that the claimants breached fundamental terms of the contract. The respondent's rejection of goods was commercially justifiable. The final word is, the claimant claims for ringgit is hereby dismissed in full, while the respondent counterclaim for 650,000 ringgit is allowed. The claimant shall bear the cost of arbitration and legal fees to be assessed. The tribunal concludes this hearing with a reminder that arbitration is a mechanism rooted in good faith, diligence, and finality. Parties are bound by these words. Thank you, Council and parties, for your time. Thank you.